PS?
Yes, ma'am.
But you didn't finish those because you got incarcerated?
Yes, ma'am.
Okay.
Right.
What's your relationship with Kamari?
It's my oldest. I talk to her every day. She tells me every day, she say, Mama, I'll pray
I don't
for you."
care,
Yeah, just answer the questions.
Yes,
because are you, can y'all hold it down, please? Are you Eric Gibson?
Yes, ma'am.
And this is cause numbers 25 DCCR 1102.
Order in the court, please. You can lower your voices. Thank you.
1102, 1103, 1104, and 1105, charged in 2 of those cases with sexual assault, and in the other 2 with aggravated sexual assault. And Ms. DeLage, what is the announcement?
Judge, I'm still working through discovery because we need to go to discovery on here, so I'm asking for a little bit more time on that.
Okay. Look. Okay.
This is a new appointment.
Yeah, it is. And so, Mr. Gibson, what I'll do is do a normal reset. That'll give Ms. DeLage more time to come out, go over everything she's received from the district attorney's office, so that when we come back at that next announcement, we'll see what you want to do on your case, okay? And is there anything that you're waiting on? Is there no DNA, nothing like that? Okay, perfect.
I
So,
think I have everything that they have, so
okay,
I just haven't gone through it.
okay, sounds good, thanks. She'll see you before the next court date. You can go back with the bailiff. Mr. Kimler, you have Kashawn Purdy. Saban. Let's see.
Judge, can we hold that just for, oh, there you go. All right, what's the steps in front of
Just on the MTRP
Yes.
case.
What's yours? What is this? Section.
Yeah, but you're injured your child.
Not a section.
Not sexual, but he's on
Mr.
probation.
Yeah, right.
Mr. Hoffpower gets everything now. They're spreading the love up
They're
there.
spreading out.
Yeah,
I see him, I get a little nervous.
right.
This association. Yeah, I read that.
Yeah.
This nation's pregnant. I don't know. Did you get something out of it when she was wearing a wristband and she actually was pregnant?
It's all that.
Right here.
Good morning. Are you Kashawn Purdy? And Ms. Purdy is on probation and cause number 24, DCCR 1272 for the state jail felony offense of unauthorized use of a vehicle. And there's a new indictment in cause number 25, DCCR 1523, charged with injury to a child, elderly, or disabled individual. Mr. Kimler has filed a motion asking for a bond in that unauthorized use case that has the motion in it. Mr. Kimler, you may proceed.
Your Honor, I think she's on deferred. I've reviewed a little bit. I haven't actually gotten discovery on the new case yet, but I have reviewed some photographs that were taken by the defendant's family with injuries. I don't want to downplay it, but it appears to be sort of a de minimis type of injury. It's not, and I'll defer to Mr. Hoffpower, may have a different opinion on that. We're simply asking for a bond on the underlying motion to revoke probation to allow her time to prepare to defend the injury to a child case.
I can't, hold on. Y'all, I'm having a hard time. So if you're talking about a case, for some reason, I'm having a hard time. I've got a cold and my ears are stuffy. Y'all need to step in the back. If you're not talking about a case, I need you to really be quiet.
And I'll try to
Speak up, please.
And additionally, she is pregnant. I think that, and I did receive a write-up from, that was emailed to me from the jail. And to the best of my understanding, it appears she was wearing, I guess, a blue wristband to indicate that she's pregnant. There was some, I don't know, misunderstanding on the part of the jailer as to whether some other female inmate had given her the wristband. Evidently, they get extra rations or extra portions of food and their vitamins and stuff if they're pregnant. But It appears from the write-up that she actually is pregnant, so I don't know that it was that a disciplinary write-up or what the purpose of the write-up is, but she certainly, other than that, hasn't had any problems to my knowledge.
All right, you want to put on some evidence with regard to her ability to pay? Would you raise your right hand the best you can? You swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
Ms. Purdy, the judge just wants to know your ability to pay a bond, to actually come up with the funds necessary to pay a bond when you get out of jail. What's your financial situation right now, just generally speaking?
I had got laid off back in September, but I had got another job at the end of October. So I'll be able to pay my bond.
How much do you have available now to pay a bondsman as far as money that's put aside to pay a bonding fee to get out?
Like 500, 600.
Okay, and then hopefully after that you get your job and we'll be able to work.
Yes, sir.
Okay.
Yes, sir.
Do you have any savings or checking, money in the bank, anything like that?
No, sir.
Do you own your own residence, your own home? Do you own your own?
Rent, yes, sir.
You rent? Do you own any vehicles?
No, sir.
What about any other thing of value that you might own? Anything?
No, sir.
That's what it's.
I need to know, how many children do you have?
I have 2 and 1 on the way.
And where do they live, with you?
Yes, ma'am.
So if you make bond, where are you going to be living and with who?
At my home.
Who lives at your home?
Me, my 2 kids, and my fiance.
Did Child Protective Service get involved in this?
Yes, ma'am. They closed the case. And I was also taking anger management and parenting class also.
Through CPS?
Yes, ma'am.
But you didn't finish those because you got incarcerated?
Yes, ma'am.
Okay.
Right.
What's your relationship with Kamari?
It's my oldest. I talk to her every day. She tells me every day, she say, Mama, I'll pray.
I don't
for you."
care,
Yeah, just answer the questions.
because you're not going to be allowed to be around them if you make bond. So you got to figure something else out until I figure out what's going on with your
Yes, ma'am.
case. So that's going to be, who are they with now?
My mom.
Okay. So if you make a bond, then they're going to have to remain there. You're not going to be able to have unsupervised contact with them until further order of the court. Do you understand? That would be a condition of your bond.
I totally understand.
Okay. Mr. Hoffpower, what's the state's position?
Judge, that was our concern, is the new offense. I disagree whether or not it was de minimis or felony court.
Well, and for the record, I am reviewing the probable cause in that case, just to get a little bit of information on what the allegations are.
I was talking about a photograph, so.
What else?
Simply judge that she's on felony probation and allegedly commits a felony. We'll leave it to the court's discretion.
All right, so I'm going to grant the motion to set a bond in cause number 24 DCCR 1272. I'm going to set that bond at $30,000. A condition of that bond is that you have no unsupervised contact with any children, including your own, and that you complete whatever CPS is requesting that you do. So if they started classes, you need to continue with those and whatever they request of you. Do you understand?
Yes, ma'am.
All right.
Comply with secret.
All right, you can go back with the bailiff.
I just set her for an announcement again.
Mr. Macon,
Yes, Your Honor.
you have Calvin Hawkins.
Yes, Your Honor. We would ask for a very short recess.
Hold on, let's get everybody up here, please.
I was reading.
knocking that building still is. I don't know about that.
That's just nice.
I got names at one time, so
We'll give it very much.
I'll look and see what you just did.
Grow 6 inches.
Good morning, you're Calvin Hawkins Jr. And Mr. Hawkins is charged with unlawful possession of a firearm by felon in cause number 24, DCCR 1160. And Mr. Macon, what is the announcement?
We're going to have, at this time, announce trial on the underlying case. We have a motion to set a reasonable bond on Mr. Hawkins. It's presently set at $100,000.
I'm not prepared to go forward on that.
I don't see a motion. When was that filed? And what do you mean underlying case? I only see one case. Am I missing something?
Just possession of a firearm.
Right. Okay, so there's just the one case. I don't see a motion. Did you file a motion for a bond?
I've got one right here.
I don't know that our office received it, Judge, I'm not prepared.
I don't have it either.
I'll clear that up with the,
So, what we'll do is I will reset it for an announcement. Once that motion comes through, if there's a date before that, we'll get it set as quickly as possible on the bonds
Thank you.
setting. Okay, thank you. You can go back with the bailiff. What is, that other attorney?
The courtroom unfolds like a series of crossroads, where every defendant faces a moment that could redefine their future. Judge Simpson presides with calm authority, moving from case to case, each one heavier than the last. Eric Gibson's appearance comes first, charged with multiple counts including sexual assault. His case is reset, a temporary pause before consequences inevitably return. Next comes Cashin Party, already on probation and now facing a new indictment involving injury to a child. Pregnant, unemployed, and emotionally strained, she testifies about her finances, her children, and her attempts to comply with CPS requirements. The judge listens carefully, balancing compassion with caution. Bond is granted, but at a steep price. Strict conditions are imposed, including no unsupervised contact with children, a reminder that freedom in this courtroom is never unconditional. As proceedings continue, Calvin Hawkins seeks relief from a high bond, only to be delayed by missing paperwork, another example of how procedure can quietly decide a person's fate. Then the tone shifts sharply with Braxton Hughes. His burglary case opens a raw conversation about addiction, accountability, and a criminal history stretching back decades. Hughes speaks of sobriety and faith, but the judge confronts the record: revoked probations, repeated failures, and broken chances. Despite brief sympathy, the sentence is firm: 4 years in prison. Finally, Thierry Hartley stands accused of aggravated robbery, facing the terrifying reality of habitual offender status. Offered 20 years or risking life behind bars, he rejects the deal. The judge ensures he understands the cost of that choice. As the docket closes, one truth lingers: every decision echoes far beyond the courtroom walls, and justice rarely forgets.
Good morning, are you Braxton Hughes? And this is 25 DCCR 1124. Mr. Hughes was previously in court, entered a plea of guilty to burglary of a habitation. The agreement was for a cap of 4 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Are there any additions or corrections?
None aware, Judge.
Judge, obviously, I'm aware of some of his criminal history, others not quite so much. I would think that the 4 would probably be on the low end in your opinion, but I defer to whatever you think.
Okay, thank you. Mr. Parker, you may proceed.
Your Honor, I mean, I've talked to him and I've heard some stories in my life, but I feel that he's telling the truth, not that it's a defense, but they were getting pulled over. He had some other guys in the car. There was drugs in the car. They took the drugs. He leaves and goes to a house that he used to know the person that lived there. he walks in, gets him something to drink and has a thermos or something like that, and then turns around and she's standing there. He had obviously scared her and, and didn't know it, and it wasn't the person he knew that lived there. And he said, call the cops, and he walked outside and sat down and waited for the cops to show up. And that's what happened. It's not like he was going in there, to try to injure her. I don't think. He walked in the wrong house, and he did take the thermos or mug, and it's simple as that. I think he'd like to talk to the court, Judge, and we're asking for probation, Judge.
All right, go ahead, Mr. Hughes.
Your Honor, what he said is correct. I can't say anything else. I was doing drugs about a year and a half, but I was like a lightweight. I took the drugs and was not really acting like myself, and I went and knocked on the door and went in there. I was trying to get away from the people I was with, but long story short, after this event, I did sober up. Started going back to church with my mom. I was in for treatment at the Right Step. I tried to get into treatment there. I was doing the paperwork there, trying to get help, but I was sober for a couple months out there on the streets, and I'm not really like a typical druggie type. I don't go around and commit crimes or nothing like that.
Your criminal history would say otherwise.
This has been a long time.
I understand, but be careful how you word things, because you've been a criminal since 2002. You've got 1, 2, 3, 4 misdemeanors. You've got 1, 2, 3, 4, 5 felonies. Many more that you were arrested for, and obviously doing some things that you kind of got either rejected or dismissed because of pleas on other stuff. So I understand that some of those were a long time ago, but it's still not a pretty picture.
I understand that. Most of my previous crimes and stuff, they were behind addiction and stuff. But life's a journey, and I haven't, I still was battling with addiction, but not committing crimes. This, I know, with the standing here in front of you, charged with a crime, I could understand, how it sounded.
Yeah, I mean, and it's at what point do you go get that help before you commit a crime? I do appreciate what you've done since the offense, Ms. Malfino.
Judge, I would definitely agree that this is an odd fact pattern, very odd. I feel sorry for the situation that he's in with his addiction, but I feel more sorry for the young lady who was scared out of her mind when he was in her house, acting probably like a complete psychotic animal with tinfoil on his head. So I don't know that probation at this juncture would be a viable option, Judge, or a good thing for the community, but I defer to whatever you think is best.
If your history had, one of the things that is sticking out is that every probation you've ever gotten has been revoked. So you've never been successful on probation, and so.
Completing the last one.
Huh?
I did complete the last one.
The last one that I see was the federal sentence where your supervised release got revoked.
I did get revocation, but I got back out on probation and completed it.
Okay. At this time, Mr. Hughes, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation. Sentence you to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, you can go back with the bailiff. And this is Ms. Malfino. I don't usually, this is one that I would potentially consider,
Right.
reconsider at the appropriate time if you want to
Okay.
file a motion for shock. Mhm.
Okay.
So you just,
Maybe with safety or something.
something like that. Let's just see, and it all depends on how he's doing in there, but you've got to do it within 6 months.
I understand.
And I would consider it. Tyree Hartley, I'll do that one and then I gotta go back. Yeah, this is yours, Ms. Malfino. Good morning. Are you Tyree Hartley? And Mr. Hartley, in cause number 25 DCCR 0842, you're charged with the first-degree felony offense of aggravated robbery, and that's from April 22nd of 2025. Your indictment alleges that you were previously convicted of harassment by a person in a correctional facility, a third-degree felony, August 5th of 2013. And after that was final, you were convicted of evading arrest or detention with the use of a vehicle, a third-degree felony, December 21st of 2022. And then again, an evading arrest or detention with a vehicle, November 13th of 2023. And what that means is that if you go to trial and you're found guilty, you would be considered a habitual offender, and your minimum punishment would be 25 years in prison up to 99 years or life. Do you understand? Answer out loud, please, for me. Thank you. And I have here on the tablet a plea bargain rejection that has your signature with Mr. Parker's that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to waive that enhancement for habitual for a 20-year sentence in prison. You have every right to reject that. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to plead guilty. And do you understand all of that? And do you want to reject that offer and go to trial? And is there any reason to believe that that offer would change?
No, Judge, it would go up substantially.
So I want to make sure you understand, I don't want to accept that offer after today either, okay? And so if you change your mind, you can plea open to the court or to something else, but it won't be to that, all right? So I will put your case on the trial docket. Mr. Parker's been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? All right, so Mr. Parker, you're released. We will appoint someone today. They should be out to see you very soon to begin preparation for trial, okay? You can go back with the bailiff. All right, everybody, I have to take...
This is not just a case. This is a fight for justice, where one question from the judge can change a life forever. The silence of the victim, the arguments of the lawyers, and the verdict that decides the truth. Welcome to Court and Courtroom, where every case reveals a new truth, and every truth leaves a lasting impact.